The law never asked a boy to commit a crime to end up at Marianna. 3 words were enough: truancy, incorrigibility, dependency. Florida's own term for a child with no parents left to claim him. None of the 3 required a trial. The school ran under that law for 111 years, and in its own file it lists 81 boys who died on the grounds. Across all that time, exactly 0 people were ever convicted of anything that happened inside the fence. This is the story of Dozier, the machine built to fix children, and the men who kept deciding there was nothing here to charge. The rule that put him there did not appear by accident. Here is the part that most people get wrong about why it existed at all. In 1897, the Florida legislature passed an act to build a reform school, and the language of the act was almost entirely about protection. Boys who broke the law, the reasoning went, should not be housed with adult convicts. A separate institution would teach them a trade, teach them to read, and return them to their families as working men. 5 commissioners, appointed by the governor, were charged with running it. They reported back to the legislature on what they found. Not every year, but every 2 years. An entire election cycle could pass between one official look at the school and the next. On paper, that was the whole design: a place to fix children, and a board to watch the people doing the fixing. The school opened on January 1, 1900, as the Florida State Reform School, on land outside the small panhandle town of Marianna. It changed names 3 more times over the next 67 years. Florida Industrial School for Boys in 1914, Florida School for Boys in 1957, and finally, in 1967, the Arthur G. Dozier School for Boys, named for a man who had spent 11 years as its superintendent and had died earlier that same year. The state does not appear to have discussed whether naming a school after a former superintendent was a compliment or a liability. It simply did it. Here is the part that most people get wrong about a reform school built at the turn of the century. The men who wrote the founding statute were not being cynical. Committing a boy to Marianna instead of an adult prison genuinely was, in 1897, a step forward from what had existed before. That has to be said plainly. It is true. And the story that follows only makes sense if the starting point was a real reform, not a con from day one. In practice, the same statute that promised protection also set the terms for who could be committed there. Those terms were wide enough to catch almost anyone the state wanted caught. A boy did not need to steal anything. He did not need to hurt anyone. Truancy, missing school, was enough. Incorrigibility, a word with no fixed legal definition, was enough. It meant, roughly, that a parent or a judge had decided a child was too difficult to manage, and dependency was enough on its own, the state's term for an orphan, a child with no family to claim him, who had broken no law of any kind and was committed anyway, because there was nowhere else built to put him. Dependency is doing a great deal of work in that sentence. It is the word a state uses when it wants to lock up a child for the crime of having no one. The reach of that legal net went well past truancy and orphanhood, and it did not stay confined to routine cases. In July 1963, during the civil rights sit-ins in St. Augustine, 2 black teenagers arrested at a segregated lunch counter, Willie Carl Singleton and Samuel White, 2 of the 4 young protesters who became known nationally as the St. Augustine Four, were sent by a local judge to a reform school in Marianna after their families refused to sign a pledge that the teenagers would stop demonstrating. Accounts differ on exactly how long they were held there, somewhere between 5 and 6 months, before Florida's governor ordered their release under mounting national press attention. The charge on the paperwork was the same one used for hundreds of other boys committed that decade: incorrigibility. The 2 girls arrested alongside them that same day were sent to a separate reform school for girls elsewhere in the state, a reminder that Marianna was never the only address this legal machinery used, only the one most people now remember. Within 3 years of opening, the reform on paper had already produced a specific reality on the ground. An 1903 inspection did not merely note that boys were sometimes restrained. It found the practice common enough to describe as routine, meaning that, on an ordinary day that year, a boy who could not keep pace with a work detail might spend it in leg irons, in front of staff who did not consider the sight worth hiding from a state inspector. The commissioners who received that report did not close the school, dissolve the board, or remove the superintendent. They kept operating, and the state kept sending children. 11 years after that inspection, in 1914, the same year the school's name changed for the first time, a fire tore through one of the dormitories and killed at least 6 students and 2 staff members. There is no indication in the surviving record that dormitory procedures were changed as a result. Over the school's first 13 years, Florida investigated its own reform school 6 separate times, 6 state-ordered inspections in 13 years of one institution. That is not a small number for a state government in that period, and it says something the annual reports do not say directly. Whoever was running Marianna generated enough concern, repeatedly, to justify sending someone to look. And after each of the 6, the board kept the same structure in place, and the school kept running exactly as it had before the inspector arrived. By the time it reached its full size, the campus covered roughly 1,400 acres, for years one of the larger reform school properties of its kind in the country. A boy committed there was not being sent to a single building. He was being sent to something closer to a small, self-contained town, with its own farms, its own print shop, its own laundry, and its own cemetery. Depending on the decade, its population ran anywhere from just over 100 boys to more than 900 at once, all of it run by residents who had committed no crime that would have put an adult in prison for a single day. This is worth saying now rather than later. It is the same school that, 80 years afterward, a Pulitzer Prize-winning novelist used as the direct model for a novel called The Nickel Boys, and that a feature film carried to theaters under the same title in 2024. Neither the novelist nor the filmmakers needed to invent anything about the mechanism. The record already had it. There was also a racial line built into the campus from its earliest years, and it shaped who did which kind of work. Black boys committed to the school were segregated from white boys and assigned the heaviest labor on the property, picking cotton, cutting timber, making brick, without pay. Local businesses in and around Marianna benefited from that labor directly. None of it appears in the founding statute. All of it appears in what the school actually became within a few years of opening. It would be dishonest to suggest that every boy who passed through Marianna over those 111 years ended up in a lawsuit, a legislative hearing, or an unmarked grave. Colson Whitehead, the novelist who later drew on the school's history, has pointed out that roughly 600 boys moved through the institution in a typical year, and the overwhelming majority of them are not named anywhere in this account. That may mean they were never harmed there. It may only mean nobody ever asked them. Both possibilities belong in the same sentence as the other. By the time the first decade closed, the school had settled into a pattern that would hold, with only cosmetic changes, for the rest of its existence. A stated mission of protection, a legal net wide enough to catch children who had committed no crime, a board that investigated itself and never once found reason to stop, and a local economy that had quietly come to depend on the labor of the children it was supposedly reforming. That was the arrangement Florida built. What it looked like from the inside is a separate question, and it starts with a single building on the property that the state itself gave a name. This channel has looked at other schools built on the same theory, around the same period, and there is a comment section below where readers point us to the next one. On paper, the state was watching. In practice, watching and doing something about it were 2 very different jobs, and only one of them was ever funded. A boy did not walk into Marianna off the street. He was committed, the legal term, used on the intake paperwork, the court order, and the annual report alike. A judge signed the order committing him. For truancy or incorrigibility, that judge did not need to hold anything resembling a full criminal trial. A hearing, sometimes a short one, was enough. Once the order was signed, the boy became, in the language the state used about him for the rest of his stay, a ward of the state. Florida had legal custody of him in a way no ordinary parent ever has. For an amount of time, no court was required to specify in advance. Intake meant a haircut, a number, a uniform, and an assignment to a dormitory and a work detail. The term the school used for a labor assignment, whether that was the laundry, the fields, the print shop, or the kitchen. Boys on the laundry detail worked 9 hours a day. Boys on the field detail worked longer, depending on the season. None of it was framed as punishment. All of it was framed as training. Assignment to a detail followed the same segregated lines that ran through every other part of the campus. Black boys and white boys were housed separately, and for most of the school's history, the heaviest outdoor labor, the cotton fields, the timber, the brick making, fell disproportionately to the black boys on the property, unpaid, rotation after rotation, for decades. The detail a boy was assigned to on his first morning said more about what his year would look like than almost anything else on his intake form. Isolation was its own category, separate from discipline in the White House, used for different infractions. On paper, it was a temporary measure. In practice, boys could be confined alone for days at a time, and the practice survived under a series of different administrative names over the decades. The language changed even when the room did not. The federal report that would eventually close the school listed unconstitutional use of disciplinary confinement as one of its central findings, describing a practice that had, by then, been reworded and reapproved by the school's own administration more than once. Discipline itself was a separate matter again, handled in a separate building, and the building had a name the boys gave it themselves: the White House. It had not begun as a punishment chamber. The building had started as a dairy structure, meant, originally, for milking cows, and was repurposed once the school needed somewhere private to administer physical discipline. Exactly what crossed the threshold into a trip to the White House was left, in practice, to the discretion of whichever adult was on duty that day. No surviving document sets out a fixed list. An industrial fan was installed near the bed, where boys were made to lie down. Survivors who later spoke about the building, and whose accounts were used decades afterward when the state built a memorial on the same spot, said the fan ran the whole time. Boys at the school had their own name for what came out of it: the ice cream factory, because a boy could walk out with bruises in every color. The fan is a small detail, and it survived everything that came after it: the closure, the years of abandonment, even the eventual memorial built on the same foundation. It is a detail worth holding on to. It comes back later. The paperwork had a gentler word for what happened in that building. The word was spanking. For 39 years, from 1943 until his retirement in 1982, one man administered the school's discipline in that building more consistently than anyone else on staff: Troy Tidwell. He started at the school young, worked the barber shop, ran the canteen, worked in the finance office, served as a cottage parent, and finished his career with the title Home Life Supervisor. Hundreds of former students, decades later, would identify him by a nickname of their own: the One-Armed Man. Under oath, in a deposition taken as part of a civil lawsuit filed against him by more than 300 former students, Tidwell described what he did in the White House in his own words. He called it spanking. He said he struck a boy 8 to 10 times per infraction with a leather strap, that it was state-sanctioned discipline, and that no boy had ever been beaten in his presence. That is not a figure of speech, and it is worth sitting with for a moment. The man most often named by former students as the person who administered the beatings testified, on the record, that beatings did not happen, that what happened was spanking, sanctioned by the state, administered by an employee of the state, in a building the state owned, and recorded nowhere as anything other than discipline. The words on the form and the sound in the room were, by every account other than his own, two different events, and that was the point of using the softer word in the first place. A form that says spanking does not require a follow-up, a form that says beating does. None of this, the intake, the detail, the White House, the word chosen for what happened inside it, required anyone above a superintendent to sign off on a given afternoon. It ran on its own, day after day, for decades, inside a system that had already investigated itself 6 times in its first 13 years and found nothing worth stopping. For 39 years, the strap in that building never had a different hand on it. Then, in October 2008, the men who had felt it stood outside its door and asked the state to finally look. On October 21, 2008, a ceremony was held on the grounds of the closed discipline building. A group of former students, men now in their 60s and 70s, who had started calling themselves the White House Boys, stood outside the building where they said they had been beaten as children and watched state officials formally seal it. The ceremony was meant to close a chapter. It opened one instead. Media coverage of that ceremony reached Governor Charlie Crist's office, and Crist directed the Florida Department of Law Enforcement to open a formal investigation into the allegations. FDL spent more than a year gathering statements, interviewing survivors, reviewing what records existed, and attempting to interview former staff. The investigation covered not just Dozier itself, but the maximum risk facility next door, the Jackson Juvenile Offender Center. Together, the state referred to the combined site by an administrative name, the North Florida Youth Development Center, one that appeared on organizational charts far more often than it ever appeared in anything a boy who lived there would have called it. Troy Tidwell was one of the men Fiddle wanted to speak with. He declined. The agency noted that his cooperation could expose him to criminal prosecution, and he was not required to give it. He did, separately, sit for a videotaped deposition in the civil lawsuit brought against him, a different legal process, with different protections, where the questions came from the plaintiff's attorneys rather than from the state. The investigation that produced the eventual decision had, by its own account, interviewed dozens of the men who came forward and reviewed decades of surviving institutional paperwork, intake ledgers, disciplinary logs, the annual reports sent to the legislature every year the school operated. All of it went into the same file that produced both the 81 death count and the conclusion that there was nothing left to charge anyone with. On February 25, 2010, the state attorney for the circuit that includes Marianna sent a letter closing the matter. The office had reviewed FDL's findings and concluded there was insufficient evidence, no tangible physical evidence, in the language of the decision, to support criminal charges against Tidwell or any other former employee. The civil lawsuit brought by more than 300 former students was, separately, dismissed. Here is the part that most accounts of this story leave sitting in silence. It is easy to miss, unless the two decisions are read side by side. FDL's own investigation, the same one that produced the letter declining to prosecute, had already documented 81 deaths in the school's history as part of its file. The number was there, in the agency's own paperwork, at the exact moment its findings were used to close the case rather than reopen it. 20 months later, a different authority looked at the same set of facts. It reached the opposite conclusion. The United States Department of Justice had opened its own investigation in April 2010, under federal civil rights law, examining conditions at Dozier and the adjoining Jackson Juvenile Offender Center. On December 1, 2011, the department's Civil Rights Division sent its findings to the governor. The language was measured and specific. There was reasonable cause to believe a pattern of unconstitutional conduct had occurred, that youth confined at the facility had been subjected to conditions placing them at serious risk of avoidable harm, and that the problems amounted to systemic, egregious, and dangerous practices exacerbated by a lack of accountability and controls. By the time that letter arrived, Florida had a different governor than the one who had ordered the original state investigation. Charlie Crist, who directed FDL to look into the White House in 2008, had left office in January 2011. It was his successor, Rick Scott, who received the federal findings that December, a governor who had not been in office for any of the events the report described, and who inherited a case that had, by then, already been closed twice, once by the state's own declination letter and once by the school's own closure 5 months earlier. Reasonable cause, in the language a federal civil rights investigation uses, is not the same standard as proof beyond a reasonable doubt in a criminal court, and it was never going to produce an indictment on its own. It is the standard used to compel a state to fix ongoing conditions going forward, not to punish anyone for what had already happened to a boy who was no longer there to be protected by the fix. Two government bodies, one set of underlying facts. A state prosecutor who closed the file for lack of evidence, and a federal civil rights division that, using the same broad record, found a pattern serious enough to put in writing to the governor of Florida. Nobody who signed either document ever had to be in the room when it landed. That was not a flaw in the design, it was the design. A state prosecutor's office, working from outside Marianna, reviewed a file and mailed a letter. A federal civil rights division in Washington reviewed a different slice of the same history and mailed a report. Neither office had to walk past the White House to reach its conclusion, and neither conclusion required a single individual, not a superintendent, not a disciplinarian, not a commissioner, to answer for a specific death. Somebody had to sign each of those investigations closed, one boy at a time, across more than a century of paperwork. Here is one of the boys it was signed about. George Owen Smith was 14 years old when Florida committed him to Marianna in 1940. The charge that put him there does not survive in complete form in the public record. What survives is the outcome. He was dead within 4 months of arriving. Before it, there is very little to go on beyond the frame of an ordinary childhood. He had a mother, and he had a younger sister, Owen, who would spend most of her own life trying to find out what had happened to her brother. When Smith stopped writing home, his mother contacted the school. The reply she received said he had run away. That was the entire explanation the state offered a parent whose son was in fact already dead. A single sentence, a single verb, no further correspondence. She did not accept it, at least not entirely. At some point afterward, she drove to Marianna to find her son's grave. Nobody at the school would show her one. There is no record of what she was told standing at the gate, only that she left without an answer, and continued, for the rest of her life, without one. She died in 1980. Her son's remains were still in unmarked ground behind the school when she did. It is worth saying plainly what that meant for a family in the middle of the 20th century. A 14-year-old boy, committed to a state institution for reasons the record no longer preserves, dead within 4 months, and buried by the agency responsible for his safety in a grave with no name on it, while that same agency told his mother he had simply left. Nobody wrote down what actually killed him. The school's paperwork says he ran. There is no coroner's file that says anything at all. 74 years passed with that gap sitting exactly where it had opened. In 2012, researchers from the University of South Florida, led by forensic anthropologist Aaron Kimmerly, began the work of locating and excavating unmarked graves on the old campus, using ground-penetrating radar to find what the school's own survey maps had never recorded. By the time the most intensive phase of the work was underway, the team had grown to more than 50 people, drawn from 9 different agencies, university researchers, forensic specialists, and state and local law enforcement, all working the same 1,400-acre property the school itself had once run as a self-contained operation. Over 4 months in the fall and winter of 2013, the team recovered 55 sets of remains from a section of the property called Boot Hill, a site the state's own file had accounted for with 31 marked crosses. In August 2014, the team announced its first positive identification. Matching a set of remains to a name required more than a shovel and a lab. It required a living relative willing to give a reference sample decades after a family had often been told nothing more than that a boy had run away. The same explanation the school gave Smith's mother in 1940, repeated, in one form or another, in case after case. In Smith's, the match came from his sister. DNA drawn from the remains was compared against a sample from Owen Krell, then in her 80s, who had waited 74 years for it. His remains were returned to his family and reburied under his own name, beside relatives who had spent decades wondering where he was. He was one name recovered from that field. 55 sets of remains came up with him. By the time the identification project's final report was released in January 2016, researchers had positively confirmed only 7 of the 55 by DNA, with 14 more identified through other supporting evidence. 34 sets of remains, more than half of what was recovered from that ground, remain without a name attached to them at all. That is more than half. Still unnamed. Identifying skeletal remains that have been in Florida clay for 70, 80, or more than 100 years is not a fast process. It typically depends on a family reference sample, often mitochondrial DNA, passed down along the maternal line, compared against whatever can still be recovered from the bone itself. Where no living relative could be located, the case simply stopped moving. A name stayed missing, no matter how much the team already knew about roughly when or how that person had died. Smith's case became, in the years that followed, the one researchers and journalists returned to most often, not because his death was unusual for the school, but because it was, for once, fully resolved. A boy went in, a boy died, a family was told a lie about why, and 74 years later, science did what the paperwork, the board, the 6 early investigations, and the 2010 declination letter had never managed to do. It put his name back where it belonged. Erin Kimmerly would spend another decade on the wider identification effort before publishing her own account of the project in 2022, under the title, We Carry Their Bones. Whitehead, whose novel had already carried the school's history into the national conversation, provided a blurb for her book before it was printed. That resolution is the exception in this story, not the rule. It is worth remembering, moving into the next set of numbers, that Smith is the case with an ending. Most of the 55 are not. There is more of this particular account in the description below, and more schools like it waiting in what this channel covers next. He was one name recovered from that field. The full count of what was actually buried there, and what it eventually cost the state to acknowledge it, is its own arithmetic, and it is worth doing slowly. Start with the number the public could see before anyone dug anything up: 31. That is how many graves were marked with small white crosses at Boot Hill when Florida's own investigators looked at the cemetery in 2008 and 2009. For most of the school's history, that was the only number anyone outside the institution had reason to know. Set beside it the number the state's own criminal investigators produced, separately, as part of the same 2009 to 2010 inquiry that later declined to prosecute anyone. 81 deaths, documented in the school's own file across its operating history. 81 against 31 is already a gap of 50 inside a single agency's own paperwork at the same time that agency was telling the public there was insufficient evidence to act. And no, that is not a rounding error. 31 marked graves and 81 documented deaths describe the same institution, produced by the same state government, using 2 different counting methods that were never reconciled before the file was closed. Then came the University of South Florida's fuller reconstruction, completed after years of archival work alongside the physical excavation. Researchers traced records of at least 98 deaths at the school between 1914 and 1973 alone, a window that does not even cover the school's full 111-year run. Of those 98, the team was able to determine that 45 had been buried somewhere on the school grounds, 31 had been shipped elsewhere for burial, and 22 had no burial location on record at all. 22 boys, accounted for as dead in the school's own history, with no paper trail showing where their bodies went. 98 deaths across 111 years works out, on average, to fewer than 1 death a year. Averages like that are exactly what an annual report is built to produce. A single small number, repeated, year after year, that never has to explain which specific stretches were worse than the average, and by how much. The surviving record does not break the 98 down year by year in any way that would answer that question. That gap belongs on the list too. Set against the reconstructed total, the number actually recovered by shovel and ground-penetrating radar, 55 sets of remains excavated from Boot Hill over 4 months in 2013. Every one of the 55 yielded bone, teeth, or grave good evidence, buttons, a coffin handle, a child's marble, confirming a burial where the state's own 1990 survey maps showed nothing at all. Of those 55, only 21 have ever had a name reattached to them, 7 confirmed through direct DNA matching, 14 more identified through supporting evidence short of DNA. 34 sets of remains, recovered and examined, remain listed as unidentified as of the most recent published findings. Run the numbers in sequence, and if you follow them in order, the arithmetic moves in only one direction, never toward a smaller total. 31 graves the public could see, 81 deaths in the state's own criminal file, 98 deaths in the university's fuller archival count, 55 bodies actually recovered from the ground, 21 names restored, 34 still missing. At no point does a later, more careful count produce a smaller number than an earlier, less careful one. In 2017, 6 years after the school closed, both chambers of the Florida legislature passed resolutions formally apologizing to survivors of Dozier and the related Okeechobee School, calling their treatment cruel, unjust, and a violation of human decency. The apology carried no funding and required no admission of individual wrongdoing by anyone who had worked there. The compensation program would not arrive for another 7 years. There is a financial arithmetic to set beside the human one. In June 2024, Florida's governor signed a bill establishing a one-time compensation program for living survivors confined at Dozier or the related Okeechobee School between 1940 and 1975, funded at $20 million. Applications opened that September. Within roughly a year, more than 900 had been filed, and the state had approved upward of 760 of them, at an average payment worked out to something in the neighborhood of $21,000 per person. The eligibility window is worth pausing on for a moment. It begins in 1940 and ends in 1975. Anyone confined at the school in its first 4 decades, the same decades that included the 1903 leg iron inspection and the 1914 dormitory fire, falls entirely outside the years the payment program covers, whether or not their remains were ever among the 55 recovered from Boot Hill. Qualifying for that payment was not simple. Applicants had to locate their own school records from a facility that had been closed for well over a decade and provide a notarized personal account of the abuse they said they had suffered, decades after the fact, often with no surviving staff member left to confirm or deny a single detail. Some of the men who applied were already in their 70s and 80s by the time the paperwork was finished. The men who stood outside the White House at its 2008 sealing ceremony waited 16 years for that check. Some of the men who might have qualified did not live long enough to receive one at all. The program compensates only survivors who are still living to apply. $20 million for a program covering 35 years of documented abuse arrived roughly a century after the school opened and more than a decade after the state's own investigators had already put 81 deaths on paper and decided there was nothing to charge anyone with. Whatever that arithmetic says about the value the state eventually assigned to what happened at Marianna, it says nothing about why it took that long to assign it. That question belongs to a different set of decisions, the ones about what finally closed the school in the first place. By the time the state finally acted, the record of warnings was not short. In April 2007, the Department of Juvenile Justice fired the school's acting superintendent and another staff member following an internal investigation into abuse allegations, calling for what the department's secretary described, at the time, as a change of culture. The change did not hold. 18 months later, the White House boys stood outside the sealing ceremony, and the pattern that had produced 6 self-investigations in the school's first 13 years produced its most consequential one yet. In 2009, the Tampa Bay Times published an 8-part investigative series into the school's history, drawing on state records, court documents, and interviews with dozens of survivors. The series was reported largely by journalist Ben Montgomery, with photographs by Edmund Fountain, and it did something none of the 6 earlier state investigations had managed. It reached readers well outside Florida, and it stayed in circulation long after the newsprint it was printed on would ordinarily have been recycled. By then, pressure had moved from newspapers to federal agencies. On April 7, 2010, the United States Department of Justice announced it was opening its own investigation into conditions at Dozier and the adjoining Jackson Juvenile Offender Center, under the same federal civil rights statute used to examine patterns of unconstitutional conduct inside state institutions nationwide. On May 26, 2011, while that federal investigation was still active, more than a year before it would produce any public findings, Florida's Department of Juvenile Justice announced it would close Dozier. The reason given publicly at the time was budget constraints. The announcement did not reference the pending federal investigation at all. The school closed for good on June 30, 2011, after 111 years of continuous operation. Roughly 200 employees were laid off. The residents still confined there were transferred to other juvenile justice facilities around the state. 5 months later, on December 1, 2011, the Department of Justice's Civil Rights Division sent Florida's governor its findings. Among the specific violations documented, a failure to adequately protect youth from harm, unconstitutional use of disciplinary confinement, and deliberate indifference to conditions that put children at risk. 3 separate categories, each backed by its own set of examples, all of it arriving in a report the state would face no legal consequence for. The report arrived after the building had already been emptied and the staff already dismissed. Its conclusions changed nothing about the closure because the closure had already happened, for a different stated reason, 5 months before the conclusions existed on paper. None of this was the first formal warning the state had received and set aside. In 1982, the American Civil Liberties Union sued over reports that boys at the school were being hogtied and held in isolation for weeks at a time. The lawsuit produced changes to written policy. It did not produce a single conviction, and neither did any of the investigations that came before or after it. Troy Tidwell, the man who had run discipline at the school for 39 years, lived the rest of his life a few miles from the campus, without ever facing a criminal charge connected to it. He died in April 2021, at 97, the same year George Owen Smith, had he lived, would have turned 95. Every argument that finally worked was an argument about money. The arguments about the children had been made for 60 years, in 6 early investigations, in the 1982 lawsuit, in newspaper coverage going back decades, in a 2007 firing that did not stick, and in the testimony of hundreds of men who eventually called themselves the White House Boys. None of those arguments closed the school. A budget line did. There is more of this history than one video can hold, and the comments below are usually where the next one starts. The building itself did not go anywhere in the years that followed. Neither did the number of people who had been formally held responsible in a court of law for anything that had happened inside it while it ran. The property is still there, outside Marianna, though it operates under a different name today. Following Hurricane Michael in 2018, the Jackson County Sheriff's Office took over parts of the former campus for its own use, and the site is now known locally as Endeavor rather than Dozier. Some of the old buildings still stand. The White House does too, though it no longer functions as anything but what it has become. On January 13, 2023, the state dedicated a memorial on the grounds, built around the discipline building itself. The statues in the courtyard were made by an Orlando sculptor, Frank Castelluccio, working from descriptions survivors gave him decades after the fact. Life-sized figures of boys stand facing a bed, and on it rests a leather strap, beneath the same kind of industrial fan survivors described from the 1950s and 1960s. The fan is back, the way it was always going to be. A group of White House boys attended the dedication. Some said afterward that they were grateful for it and that they were still waiting for something closer to justice. The compensation program Florida signed into law in 2024 is still processing applications. More than a decade and a half has passed since the school closed. More than 80 years have passed since George Owen Smith was committed there at 14. 34 of the 55 sets of remains recovered from Boot Hill still have no name attached to them. Whether their families will ever get an answer close to the one Ovell Krell received in 2014 is not something anyone connected to the current phase of the work has been willing to predict. The University of South Florida's search for additional burial sites on the property has never been formally declared complete. Researchers returned as recently as 2019 to investigate new ground-penetrating radar readings near the original excavation site. The school ran for 111 years under a statute that promised protection and delivered, by its own agency's later accounting, at least 81 deaths, a number a fuller reconstruction pushed to 98. Attached to 55 bodies actually recovered from the ground, 21 of them eventually given back their names. And across all of it, 6 early investigations, a 1982 lawsuit, a 2010 declination letter, a 2011 federal report, a 2024 compensation fund. The number of people ever convicted in a court of law for causing a single one of those deaths has not moved from where it started. It is still 0. We go inside the places America built to fix its children, one school at a time. And America built a great many of them,